Hey y'all, welcome back to my channel. If you're new here and you feel like you got a little bit of that common sense that's not so common, go ahead and hit that subscribe button. And if you don't, common sense is a disease that is highly contagious. So if you just hit that like or subscribe button, you will catch it, I promise. Now, today on my channel, we're going to get into pending laws in Arizona, because I think some of them may raise some concern and some of them we may like. So it's a nice little roller coaster ride going through these pending laws. Now, before we get any deeper, remember, I don't have any law training, I don't have any law degree, so don't come for me. And before we get deeper, first and foremost, my name is Key, and this is What's the Key?
For me, break for me, break the body for me.
Now, y'all, I gotta introduce y'all to little Miss Kiwi, okay? Now, little Miss Kiwi is special because she was part of the last batch of plants. I realized I'm never getting from one of those fancy plant stores again. Okay, listen, I need my plants to come from a life that wasn't as good as the life I'm going to give them. I cannot compete with what they have up there, with them, the fancy steams, the perfect light. Look, I want my plants struggling a little bit and I bring them back to life. But that's what makes Keith so special, because she's the only one that survived from when I got from a fancy plant store. So I love her, all right? Now, let's get into it. As always, if you see me looking to the right, I'm looking at my notes, and any bell you're hearing is my cat City doing kitty thing. Now, I've broken these down into different categories: crime laws, LGBT laws, school laws, immigration laws, and landlord tenant laws. And the first one we're going to go ahead and start off with is the crime laws. The first crime law is House Bill 2016, and this is an act amending Section 13-3620 of the Arizona statutes, and it is relating to the duty to report. And specifically, this is the duty to report for a member of the clergy, a Christian Science practitioner, or a priest. Okay, so we're getting into the religion and the spiritualities and things like that. Their duty to report, because if you don't know, a lot of religions have a person that you can confess to all your sins, and people confess crazy things.
I don't want to hear that, because first of all, how do you know?
So what they did with this is they updated to include the term a penitent confessor. And a penitent confessor means a parishioner, a congregant, worshiper, almost a Worcestershire sauce. Worshiper, church member, attendee, or individual who meets with a member of the clergy, a Christian Science practitioner, or a priest in the person's official capacity as a member of the clergy, as a Christian Science practitioner, or as a priest to discuss or confess to conduct and attempt to act within the confines of the penitent confessor's religion in accordance with the laws of this state. So they went ahead and added that definition and added this word into this section for all members of religion and spirituality. So it reads, a member of the clergy, a Christian Science practitioner, or a priest who has received a confidential communication or a confession from a penitent confessor in that person's role as a member of the clergy, as a Christian Science practitioner, or as a priest, in the course of the discipline enjoined by the church to which the member of the clergy, the Christian Science practitioner, or the priest may withhold reporting of the communication or confession if those people determine that it is reasonable and necessary within the concepts of religion. This exemption applies only to the communication or confession from a penitent confessor and not to personal observations that any of those members may otherwise make of the minor. So, for example, if they said that, oh, I hit my child, I hurt my child, I really get angry and aggressive with them, they cannot report that. Now, if they go along and then they see that child and that child has bruises and marks on them, then they report that. So they can't report what they hear, but if they start seeing things, which, I mean, in a way, I don't know, maybe this just shows that I should be in religion for sure. But if you confess something to me that's really bad, I'm going to be watching you like a hawkeye to catch an eye. Like, there's a lot of stuff you can confess, and I'm just like, that's part of life. You hear about that shit it's part of life. It's bad, but yes, it's part of life. Something like that with children, I'm like, Sister Anita, go ahead and can you follow him back there? Yeah, just to make sure. Yeah, that's probably why I shouldn't be religious. Because don't confess nothing to me that you shouldn't be doing, okay? And I mean that like extreme. Like if you cheating and stuff, it's whatever. But I mean like you abusing a child, that's something different.
Death to all of them.
Now, this is a section that was completely added. So outside of the penitent confessor, and the definition of that, this is also a new section. It also states, or to any communication that is not a confession from a penitent confessor. This section does not modify or limit a member of the clergy, a Christian Science practitioner, or a priest from the duty to report known or expected child abuse when acting in some other capacity that would otherwise require reporting. Communication made under any other circumstances does not fall under this exemption. Now, this section right here, and they added this is probably why they added in that penitent confessor. I think people were out here confessing things to clergymen, to a priest and stuff when they're not dressed up, maybe, you know, just everyday life, because they do know that it's a priest or a clergyman or etc. And they weren't able to do anything about it, even outside of their role. So, I mean, I can see that being pretty overwhelming for them too, to have to hear people confess all the time. What it sounds like to me is that you need to be in your church or at a church event, dressed in your thing. And this person has to be a direct member of whatever we're talking about as well. Like, you can't just be a normal everyday person deciding like, okay, I haven't been a member of this church in years. And I wonder if it just matters, like if it's a past member, do you have to be like currently up and they know of you and stuff like that? Like, does this have to do with somebody just going past the Catholic church, realizing they did something wrong, need to get it out, and they're just randomly going into the church and making confessions to people these pastors or these priests and clergymen and Christian Science practitioners have never seen? I can see that happen. I feel like that happens in movies when people go up and confess something. I feel like I even saw a crime show when the priest or the pastor couldn't hold it in anymore, but they heard something and just went to the police station like, I don't even know who this person was, but somebody confessed something to me and I gotta tell you what it is. So I wonder if that's kind of what it is. So I like that. I think that's what that law is doing. They said, look, it needs to be a member of your church. It can't just be random people off the street just coming in and confessing things. That's what I see. The next one, Arizona girl.
Be nice. I'm finding it.
I don't like you for this. Now, this is House Bill 2221, and this is about defunding the police. Let's get into it. A city or town may not reduce the annual operating budget for a law enforcement agency by any amount below the previous year's budget. If a city or town reduces the annual operating budget for a law enforcement agency, the city or town shall notify the state treasurer of the reduction. The state treasurer shall then withhold in state shared monies from the city or town in the amount equal to what they're going to reduce from the fucking police officers.
Woo, that'll do it.
The state treasurer shall continue to withhold state shared monies until notification from the city or town that the reduction in law enforcement agency budget has been restored.
That is so stupid.
Okay, some of y'all think, oh, these are crime neighborhoods. No. These could be some of the richer neighborhoods that are like, we tired of all our tax money going to law enforcement. We don't need that much money going to law enforcement. It don't got to just be the poor neighborhoods, crime neighborhoods, and stuff like that. Trust me, in those neighborhoods, they're probably not looking to decrease anyway or defund the police anyway. Those are richer cities and towns, like, okay, and our taxes could cover whatever you don't. We don't need the budget that high for them. The requirements of this section do not apply if any of the following applies. The city or town does not have the monies required to continue the annual operating budget for a law enforcement agency at the same amount as the previous
year.
If the city or town reduces the city's or town's annual operating budget pursuant to this subsection, the city or town shall reduce all other departments or agencies' annual operating budgets in the city or town first.
It's just bullshit.
It may not reduce the annual operating budget for a law enforcement agency in any greater amount than a reduction to all other municipal departments or agency annual operating budgets.
But you did this for what?
Why not?
Why?
Why not?
Why though?
And then you just pissed me off. So every other department has to. Why? So why can't somebody take away from the police and add to mental health? Add into welfare. Add into WIC.
I need an answer ASAP. Give me an answer.
Arizona, you have hit my shit list. The annual operating budgets for all departments and agencies in the city or town have been reduced at the same or greater amount as the reduction in the law enforcement agency's annual operating budget. Why the fuck does every other department have to be reduced just because law enforcement is being reduced?
When you hear yourself say that, does that sound like it makes sense? Does it sound like it makes sense?
Someone in the comments explain that to me. Maybe some of y'all can figure it out. I want to hear from both sides. I want to hear from Republicans. I want to hear from the Democrats. Why do y'all think they would do that? Why would, if law enforcement gets decreased, every other government agency has to be decreased as well? Why are they so, how much money are y'all paying to Arizona law enforcement agencies?
Give me an answer.
I don't understand why everybody else has to be reduced. Maybe adding money into other things is why we don't need the need for law enforcement to have so much money. Arizona,
You're not very pretty, and you're not very bright.
I don't like you.
I ain't gonna lie, me too.
The city or town has not experienced population growth. That's the one, I guess, one little thing in there. If it's not an increase in population, then boom, they don't need to, they can cut the budget. The city or town approved a temporary increase in the law enforcement agency annual operating budget the previous year for a one-time expense or capital outlay, and the city or town restores the law enforcement agency's annual operating budget to the same amount as before. Before this goes into place, I need every city and town to add in some extra about their police budget.
The ghetto.
Moving on to the next law. Now, this next law has to do with the sealing of arrest, conviction, and sentencing records, requirements, fees, appeals, and defining some new definitions. And this is section 1, section 13-911 of the Arizona statute. And it says a person may file a petition to seal all case records related to a criminal offense if the person was convicted of a criminal offense and has completed all the terms and conditions of the sentence that was imposed by the court, including the payment of all monetary obligations and restitution to the victims, and charged with a criminal offense and charged with subsequently dismissed or resulted in a not guilty verdict at trial. Now, that second part has been edited to read, was subsequently dismissed for any reason admitted to a civil offense. I wonder why they had to add that in there.
I need an answer ASAP.
I wonder why they had to add that in there. But they have added that in there. So for those of you who are listening and that benefits you, that is now in there. And also arrested for a criminal offense and no charges were filed. So those are reasons for their records to be sealed. It all makes sense to me. I never understand what is the need for y'all. And this is where racism plays. I know y'all gonna get, no, fuck it, it's my channel. I'm gonna talk about racism.
I said what I said.
This is where racism gets apart. They were taking black people, I would say specifically with black men, saying that they did this, knowing they didn't do it, knowing they couldn't put any evidence on it. The black person had to go get a lawyer, a public defender, etc. They get the case dismissed, but then you can just see on record, well, you know, employers are like, well, they got arrested for it, even though it's dismissed. Could he possibly have did it? No, they were just being racist and wanted to make sure that he had a jacked up record. Yeah, I like that. Now, they've completely eliminated this section. If the court denies a petition to seal case records, a person may not file a new petition until 3 years after the date of denial.
What the fuck?
That now, look, it's all out. That is gone. But what? Why was that a thing? They had to wait 3 years? Because some of y'all are like, well, maybe they weren't qualified. Listen, they could deny a petition just simply because of the paperwork wasn't filled out correctly. It wasn't on time for something. It wasn't done with this. It wasn't added that. They forgot one document to add to it and then deny them for it. It doesn't necessarily have to be because the person wasn't qualified. You cannot tell me that's not messed up. I will get irritated. If I forgot something on the document or something, say it's pending, saying, hey, currently still missing something. Like, damn, denied? It's crazy. But no, in those cases, it does happen. So I do see why Arizona took that out. Because if somebody just forgot to add in a certificate or etc., then yeah, I feel like they should be able to file back immediately. If not, just ask them for the goddamn paper that they're missing.
Makes sense to me.
All right, so that section's out. Next section is a conviction for an offense that is committed in another jurisdiction and that if committed in this state would not constitute an offense in the state may not be used against the petitioner or prohibit the petitioner from having a record sealed. For the purposes of this section, the classification of an offense committed in another jurisdiction has the classification that the offense would have if committed in this state. So this is like with New York when it comes to like marijuana and sort of, I don't know if Arizona has gender affirming laws, but certain gender affirming laws like in New York said it's not a big deal here just because it was a big deal over there. I think Arizona's doing that, and that probably has to do a lot with the marijuana laws because if you don't know, Arizona is one of the legal states. Now, this is a completely new section added into the sealed records. When a court considers whether to grant or deny a petition to seal case records for an eligible conviction, the court shall only consider the offense and conduct related to the petitioner's conviction. Okay, the court shall not consider any unproven facts or dismiss charges. And if you go back, and don't judge me, it's an early video, I'm getting my style. But my very first video was actually on acquitted conduct sentencing. They also removed that from acquitted conduct sentencing. So I'm glad that Arizona looked in and was like, yeah, I mean, why are you even considering something that was dismissed?
I need an answer ASAP.
Just keep it fair with everybody and don't. If it got dismissed, it got dismissed. Or something unproven. So that is sometimes, you know, if you watch law shows, those are those times where the lawyer will say something and they'll be like, objection. They'll be like, be careful. And they keep saying things that aren't necessarily facts related to the case. They're just like more opinions or hearsay or etc. Boom. That's probably what they're talking about right there. The time when you're reading maybe the transcript and you see a lawyer say something, but it was stop worrying about it. Don't worry about it. Don't worry about it. That's part of what I think. If the petitioner has a charge pending or is charged with an offense after filing a petition to seal case records pursuant to subsection C, all of what we just read, and the charge could result in a conviction that cannot be sealed or that could extend the time to file a petition to seal case records, the court may not grant or deny the petition until the court disposes of the charge. And I think that New York also had that in place. You can't have anything pending at the time you're trying to get that record sealed. If the petitioner is convicted of any of the following offenses, case records may not be sealed. Okay, a dangerous offense as defined in section 13105, a dangerous crime against children, a serious offense or violent or aggravated felony, any offense that has either of the following as an element of the offense: the discharge, use of threatening exhibition of deadly weapon or dangerous instrument. Not that I'm thinking about it. With that, and that's part of Arizona's laws. Nothing else is edited at this point. But with that being added in there, that means in the case of Marissa Alexander, where she discharged her weapon in Florida with her abusive husband, she would not be able to get her record sealed. That means basically any DV victim that would have to use a weapon or anything as offense and has to discharge it or something would never be able to get their record sealed. The knowing infliction of serious physical injury on another person. So that's to me looking like torture and things like that. Now that is the crime laws for Arizona. We're gonna move on to some of the LGBT laws.
I lied.
This next House Bill 2062 was introduced by Representative Fink. What this is doing is defining sex-based terms and law. They're defining how they're going to use pronouns and gender terms and relating to statutes, administrative rules, regulations, and public policies, all right? The following terms have the following meaning as used in statutes, but all I just said. Adopted by this state or by a political subdivision of this state. Boy means a human male who has not yet reached adulthood. Equal with respect to equality of the sexes does not mean same or identical. Father means a male parent of a child or children as defined by law. Female, when used in reference to a natural person, means an individual who has naturally had, will have, or would have, but for a developmental anomaly or accident, the reproductive system that at some point produces an ova. Girl means a human female who has not yet reached adulthood. Male, when used in reference to a natural person, means an individual who has naturally had, would have, but for a developmental anomaly or accident, the reproductive system that at some point reproduces sperm for fertilization of female ova. Man means an adult male, human of the male sex. Mother means a female parent of a child or children as defined by law. Sex means a person's biological sex, either male or female at birth. Includes only two sexes, and every individual is either a male or a female. An individual with a difference in sex development does not establish a third sex. An individual with a congenital and medically verifiable disorder or difference in sex development must be accommodated consistent with federal and state law. Is objective and fixed. Does not include gender identity or any other term that is intended to convey a person's subjective sense of self and may not be used as a synonym or substitute for the term sex.
Now, y'all, I told myself I was going to re-record this part and let myself know if there would be any reason not to use a gender-neutral term in law, like person, or saying like group of athletes or members of Congress. Like, is there any reason that you would have to identify a specific gender in law? And I can't think of one. I cannot think of one specific reason why you would need to name men, woman, female, male specifically, okay, in a law. Even if we get into laws that you would think specifically pertains to a male or female, such as pregnancy or menstruating, you don't have to say woman or man. You can say a person who is menstruating, a person who is pregnant. You don't have to say the gender. So I don't see the reason for having to try to, define this so much. I don't know, y'all. Y'all let me know in the comments what y'all think.
I lie.
Use of the term sex, sex discrimination, single-sex environments, and vital statistics related to it. Any policy, program, rule, or law that prohibits sex discrimination must prohibit the unfair treatment of a female or male in relation to a similarly situated member of the opposite sex. This state and political subdivision of this state may provide a separate single-sex environment for a male or female if the sexes are not similarly situated, particularly with respect to biology. A single-sex environment includes athletics, living facilities, locker rooms, bathrooms, domestic violence shelters, and sexual assault crisis centers. So this is saying you can put in those bathrooms, the gender-neutral bathrooms. You can put those in.
I lie.
The law is giving you permission to have these in the facilities here in Arizona to accommodate everybody. Any public school or public school district or this state, and in any agency, department, or political subdivision of this state that collects vital statistics related to sex to comply with state or federal anti-discrimination laws or to gather data shall identify each natural person who is part of the collected data set as either male or female. Complying with the subsection D of this section does not do either of the following: require the collection of data regarding sex unless otherwise required by law, and prevent the collection of additional data points other than biological sex. So if they want to say, hey, do you go by this pronoun? Do you go by this? Do you blah, blah, blah? They can still have all of that on record. So when after you check male, female, they can still have all the rest on record. Like, okay, you're a male. Okay, do you identify as this? Are you going by these pronouns, etc.? That's what that part is putting in.
I lie.
And they're also saying you don't need to ask by somebody's sex unless it's required by law. Now I'm wondering, do jobs require? Is that a requirement for job applications? Is sex a requirement for job applications? It's going to be something I have to look up. So the whole purpose of this act is to bring clarity, certainty, and uniformity to the laws of the state regarding sexual discrimination, equality of the sexes, and benefits or services that are specifically provided to males and men and females and women.
Now, y'all, I really need to know what possible law would they put in place that needs to define men and women and female and male, because aren't we all just human? Shouldn't we be treated fairly? I don't understand the reason to have to define man, woman, male, female. I just don't.
If a provision of this act or its application to any person or circumstance is held invalid, the invalidity does not affect other provisions or applications of the act that be given effect without the invalid provision of application. And to this end, the provisions of the act are severable. This is known as the Arizona Sex-Based Terms Act. Now, next House bill is House Bill 2359. And I don't got their names written down, but I'm going to put them in there. All right, this is related to conversion therapy for minors, unprofessional conduct, and new definitions. And this is for the state of Arizona, Section 1, Title 32, Chapter 32, Article 1. And they are adding in these two sections. It is an act of unprofessional conduct for a healthcare professional to provide conversion therapy to a patient or client who is under 18 years of age. And I'm not mad at it. I'm not mad at it.
I ain't gonna lie, me too.
And for those of you who don't know, conversion therapy is basically them trying to change a person's sexual orientation.
Okay. Whatever that means.
So if your child is gay, they'll take them to conversion therapy to make them straight. If they're transgender, they'll take them to conversion therapy to tell them that, oh, you're not, you don't really believe that, you believe this. That is what conversion therapy is. But from the stories I hear, research I've done, it's pretty traumatizing. And especially because of under the age of 18, a lot of conversion therapy makes you touch on the other person sexually. No, you don't need to be doing that with minors. Now, this does not apply to a clergy member or religious counselor who is acting substantially in a pastoral or religious capacity and not in the capacity of a healthcare professional, so that they're just talking to them about it. A parent or grandparent who is a healthcare professional who is acting substantially in the capacity of a parent or grandparent and not in the capacity of a healthcare professional. So the nurse, you can't go home and be a nurse trying to convert your child. You can be trying to talk to your child as a parent, but you can't be trying to do it as a nurse, doctors, etc. Conversion therapy means, this is their definition, means any practice or treatment that seeks to change the sexual orientation or gender identity of a patient or client, including mental health therapy that seeks to change, eliminate, or reduce behaviors, expressions, attractions, or feelings related to the patient's or client's sexual orientation or gender identity. Does not include a practice or treatment that does not seek to change a patient's or client's sexual orientation or gender identity and that meets any of the following. Neutral with respect to sexual orientation or gender identity, provides assistance to a patient or client undergoing gender transition, provides acceptance of and support and understanding to a patient or client, facilitates a patient or client's social support, identity exploration, and development and ability to cope, undresses unlawful, unsafe, premarital, or extramarital sexual activities in a manner that is neutral with respect to sexual orientation, and discusses the patient or client's moral or religious beliefs or practices. Now, also what they added in this section is basically the prohibiting of funding conversion therapy for minors. So state money or any monies, they say monies, state monies or any monies or monies belonging to any state agency, state 5 corporation, state division, state department, state commission, or political subdivision of this state without limit may not be spent for the purpose of conducting conversion therapy, providing health benefits coverage for the conversion therapy, or providing a grant to or contract with an entity that conducts or provides conversion therapy to a patient or client who is under the age of 18. You can't, in this state, with any of the state money, agency, corporation, state, if you do anything in the state, means the political parties too, you can't be giving money to places that encourage conversion therapy for minors. A state agency, state corporation, state division, all that we just named above, without limit, may not use or provide any federal monies to the entity for the purpose of conducting, facilitating, or reimbursing conversion therapy, or providing a grant to or contract with the entity that conducts or provides conversion therapy to anybody under the age of 18. I like it. A conversion therapy home? No, absolutely not. You cannot, no. And this is why when I went over the parental bill of rights for Arizona, this is why parents don't need complete control. They had to put a law in place because there are parents that will put their minor children through conversion therapy. Even after this law goes in place, there's still gonna be parents that sneak their kids off.
How dare you!
Now, the next section we're going to get into is for school laws, all right? And I like this one because they're getting into the school lunches and ultra-processed food. And if y'all don't remember, Michelle Obama was big on changing school lunches and making them a lot healthier. I appreciate this. This is House Bill 2213, and it was already been passed by the House as of February 25th, 2025. A public school may not serve or sell or allow a third party, okay, because y'all know how the vendors be coming in schools, to sell ultra-processed food on the school campus during the normal school day. So they're saying basketball games, every event's after, fine. During the day, absolutely not. And I kind of wondered, now that I remember in high school,
Back to my day.
I don't know if this became a school law for our state, or there's something that our school district decided to do. But during the day, it became to the point where you could not buy out of the unhealthy vending machines. You can only do it before school and after school. The only vending machine you could eat out during the school day was the healthy one. And at that time, it was only one. I really hope they have multiple throughout the school and just took out the bad vending machines. We ran it dry. I'm trying to tell you, when you want to snack on something, whether it's a healthier choice, kids will snack on it if it's their only choice. But I do remember that happening in high school. Be like, damn, this shit don't work. And now that I'm thinking about it, it didn't work during the school day, and this could be why. The Department of Education shall post on the department's website both of the following: a standardized form that a public school may use to certify that the public school is complying with the requirements prescribed in this section, a list of each public school that has certified to the department that the public school is complying with the requirements prescribed in this section. And that's even better. From the purpose of this section, ultra-processed foods means a food or beverage that contains one or more of the following ingredients. Potassium bromate. Write this down. We don't need to be eating this shit either. We'll put that across the screen. Titanium dioxide. Brominated vegetable oil. What the hell is brominated vegetable oil? Yellow dye 5, yellow dye 6, blue dye 1, blue dye 2, green dye 3, red dye 3, and red dye 40. Red dye 40 has been under attack for years. I took red dye 40 out of my diet years ago. It's just, and I noticed a change in just mood and everything. It's just not good. So they're going to give a sum of $3,800,000 to the Department of Education for the fiscal year of 2025 through 2026 to get this program implemented. This, as of now, will be renewing every year, that same budget. And this should help with changing out vending machines for schools, adding in those healthier choices, getting those other vendors and things like that. Immigration laws. Now, this was passed by the House and is currently in the Senate, and it's House Bill 2099. It directs the governor and attorney general to execute and assist the federal government with all actions and programs relating to federal immigration laws. And you know, I have my sympathy. I feel bad. Y'all heard me during the Lincoln run. I feel bad. But did y'all see the way they voted? And that's all I'm going to say.
I kind of feel sorry for you. Oh, yeah.
So what they're basically going to do is require that cities, towns, and counties to enforce, administer, and cooperate with federal actions, orders, and programs that relate to the enforcement of federal immigration laws, such as the Lake and Riley Act. Yeah. It contains a delayed repeal date of January 19 of 2029 for the previous provision, which is funny. And y'all know why it's funny, because that's 4 years to start implementing this in place. So I feel like Arizona be going back and forth. Like it truly gives when I read Arizona law swing states. Because I'll be like, oh, you know, I'm more liberal. Like, that's more red. Yes, no. It definitely gives swing state in Arizona. It requires the governor and attorney general to enforce, administer, and cooperate with federal actions, orders, and programs that relate to all these. It removes the requirement for the governor and attorney general to enforce, administer, and cooperate with federal actions, orders, and programs that relate to the enforcement of federal immigration laws. So at the same time, they want, it's okay, just reading over the summary. This one is the summary, not the bill. They're saying you have to follow the federal thing and stuff like that. But you don't necessarily have to enforce the federal immigration laws. You have to do it, but don't worry, the governor and attorney general doesn't have to force it. Is that what I'm getting? Is that what y'all hearing? That's what I'm hearing.
I ain't gonna lie, me too.
So the legislature found that Arizona voters overwhelmingly passed the Secure the Border Act, Proposition 314, at the 2024 general election. Overwhelmingly. This state has a high Latino population. When voters passed Proposition 314, the voters found that due to the weakness in immigration enforcement, a public safety crisis occurring in Arizona caused by transnational cartels. Now, I did read a while ago, like back in like Tucson, there's actually some cartel wars going on coming over from like the Mexican border and stuff like that. Not probably in those college areas, but like going further down, they say it does get pretty bad. So that could be what it is. They said it's caused by transnational cartels engaging in rampant human trafficking and drug smuggling across the state's southern border, which I just said with Tucson, which is down and towards the southern border. The vote further found that from 2021 to 2023, United States Customs and Border Protection encountered nearly 7 million immigrants illegally entering the United States through the southwest border. And that this number does not include an estimated 2 million gotaways who evaded encounters with border officials entirely. Based on these findings and other substantial evidence, the voters concluded, which they can't say the voters because you voted that way. Some people, yes, in this election voted against not even just the main election, for the locals, voted against their best interest. The voters concluded that the state of Arizona is being actually invaded. Okay, they're saying that with all the increase of the illegal immigrants coming over the border, they're being invaded. That Arizona's being invaded, and then there's a lot of violence, which in the southern part of Arizona, from what I'm reading, now I can't tell you all the sources are probably credible. I can't say if they're biased, racist, etc. But from what I'm reading, Tucson and below down there is really bad. And then there's other cities and stuff that they're starting to that they're starting to build housing and stuff at that. When I read up on the like areas and stuff like that, it's actually known as a big crime area from like, you know, what I just listed. So, I mean, I have read things on that. Accordingly, this legislation is necessary to address the public safety crisis at Arizona's border, to fulfill voters' as intent as expressed in Proposition 314, and to ensure that elected officials in Arizona's executive branch fully cooperate with President actions, orders, and programs that relate to enforcing federal immigration laws. Yo! I was not expecting to see the president's name like in the thing. But they're saying they're going with his actions. This is not good. This is not good.
Oh my.
Between this and the Lincoln Riley Act, and it doesn't help that the Arizona voters overwhelmingly voted for this. So in law enforcement's mind, they're like, majority of our people want this. Overwhelmingly. You know what? Let's look up the numbers. Arizona voted 62.6% to 37.4%. And then when you get down to like the Tucson area where it shows like Pino County, that's like 54%, 77% in Graham, 54% in Pima. Maricopa County voted 61%. That's the Phoenix area. That's crazy. Yuma voted 70%. Mohave, damn, yeah. So, yeah. That is the new immigration law that is coming in, where it's basically saying we don't have to enforce it, but you should be following what the president has put in place, like the Lincoln Riley Act. All right, y'all. So now we're going to get into some of these landlord laws, because I personally don't feel like landlord should be a job where you renting out to somebody is the reason why you can pay your bills.
I said what I said.
And that's enough said on that. I don't think it should be a job where you're profiting over whether somebody can keep a roof over their head or fucking not, which you're raising just so you can pay your damn bill. I don't feel like, no. I feel like landlords should be jobs given out to the government, people for the government. That's just, it's a side hustle. Not just sitting on your ass, letting stuff go to shit, saying, oh, it's not that big of a deal. I'm not calling a maintenance person. I'm not calling blase. Fuck it that your window's jacked up. Oh, well, I'm not fixing it, but I'm going to charge you to fix it for the next tenant and then not fix it. I don't think landlord should be a job where you make a profit enough that gives you a standard of living.
I said what I said.
I don't. Okay? The first one is House Bill 2904 and has to do with marijuana use in a rental unit. So what they are doing is saying, hey, in these rental units, if someone is smoking marijuana, that's not a reason to terminate them. This is a legal state. Y'all make enough of a profit. Send a cleaning lady in there once or twice a year. You're going to charge them extra anyway. How about every time you find them, stop using it for profit and greed? And use it towards actually cleaning the apartments. Because if y'all had a cleaning lady come in once or twice when a person's living there for a 12-month period, they wouldn't. And my thing is, if would y'all be acting like, it's my property, y'all destroy it, blase. Send somebody cleaning in once in a while. Even if tenants live there, say, hey, as my property, as your tenant, you get a cleaning. It's part of your rental agreement. It's already paid for from based off your rent. I have somebody go in and clean the apartment once or twice.
Makes sense to me.
You can't say we don't pay enough. We would if landlords were just trying to be rich off of whether somebody can have fucking housing. My thing is, the reason why I have such a problem with landlords is I think everybody should have housing. Everybody should have some type of housing, and landlords help prevent that. These owner entities and corporations help prevent that with their high prices, the requirements, their fees, and everything else they're trying to do to get a profit that prevents people from actually moving into houses. There should be no reason but the amount of money that people pay, etc., that rent and stuff is not at least one cleaning lady can come in and clean your apartment that whole 12 months you're living there. It's bullshit.
Stop acting like a fucking hooligan.
Now, the next House bill, I love it, is House Bill 2387, and it has to do with application fees, rental fees, and any other additional fees you have to do when applying for an apartment. Notwithstanding any other law, a landlord may not charge a prospective tenant for the cost of a background check or credit report if the prospective tenant can provide one themselves. For those of you that don't know, you can get a free credit report every year from annualcreditreport.com. It gives you all 3 major bureaus on their credit report. Okay? Now, from what I'm seeing, though, this isn't stopping them from being able to choose which credit report. So I think Arizona almost needs to go in and add, remember these laws are still pending. These are considered reputable places like annualreport.com where everybody can go and get a free credit report. It's considered a good enough credit screening. I feel like they need to almost list out, because you can go to one landlord and they're like, oh, I need your FICO. Oh, I want the TransUnion. Oh, I want your FICO car, your FICO home. Except, like, no, they gave you a score. That score that people have most access to for free is a score that everybody should be going by.
Makes sense to me.
Me personally. But with the credit check, whatever one they pay for should be fine. Every going from tenant landlord to landlord, you shouldn't have to buy 50,000 credit reports. They don't vary that much. And quite honestly, I think a lot of third parties are being very mischievous with the results. I'm just going to leave it at that because nothing has truly came out yet. Whispers. But I do feel like these third parties are lying, for plain words, about some of the results.
That's my opinion!
They can't require more than the actual cost of a background check, credit report, or other screening process used by the landlord as a condition of receiving, reviewing, and considering the potential tenancy of the prospective tenant, meaning your labor. No, you're not doing any fucking labor, but submitting something else on an application form. And you'll make money once they are in there. What they're doing is stopping these properties in these. If y'all don't know about it, some properties will leave a unit vacant all the time and deny everybody because they're making more money off that unit off the application fees that they're charging people that are non-refundable. Think about it. If you have a $150 non-refundable fee, and let's say in that month you had over 100 people try to apply for that one apartment, not even a month, say about 50 people try to do it in a day. Because you're not telling people, hey, this has a long wait list or anything like that. They're making a profit. And in some cases, they're not even checking your background. Your credit report or nothing. They're just trying to say it's denied for this and then for that and then for etc. They can't charge for more than one rental application within a 12-month period. So if you have somebody that's on a month-to-month, 6-month, 10-month and stuff, and they're reapplying and stuff, you can't say, hey, I'm being reached. No, you can take the one that they had 6 months ago, 10 months ago. No problem with that.
Makes sense to me.
There can't be an additional fee for the use of any service, online portal, automatic withdrawal, or other similar process for making payments to the landlord. And let's fucking go. Let's go. If some of you don't know about AppFolio or don't have to use AppFolio for learning, AppFolio has started charging, I think like a few years back, for both the ACH payment and debit card payment. So there's no way you could pay on this app without being charged a fee. And for those that truly don't know, with AppFolio, your landlord could have took on that fee. For a lot of these payment apps, the landlords could pay one thing that takes on the fee. They choose not to. They choose to pass it on to the tenant. I like how Arizona's saying, no, you're going to put that shit right back. You trying to pay extra for convenience? Because that's all it is. That's all the third-party websites are. You can say, oh, it's easier for me. It's also convenience for the landlord. For those people that be like, oh, my office is only open from 11 to 1, or I'm never there. Yeah, this is another reason why y'all shouldn't have a full-time job. Y'all don't even have full access to y'all half the time. There's some people that call and never get an answer. From the office, never get a response. Never get anything. But you got an office that you paying for out of the people's rent that you don't even use. Y'all can say it's convenient for the tenants, but it's much more convenient to the landlords to have a system that automatically puts the rent and stuff in place and don't have to do it manually. So no, they can pay for their own convenience. They don't need to charge us for it. Now, the next section of this is being added. It has to do with the disclosure and tender of a rental agreement. And it has added, at or before the commencement of the tenancy, the landlord shall disclose to the tenant on the first page of the rental agreement the exact amount of the periodic rent and the exact amount of mandatory fees or expenses. The fact that the or expenses is what they're adding. Expenses, promotional, disclosure, all that is being added. Because they have things like valet trash and stuff they will never tell you about until it's time to pay your bill. And then you're like, what the fuck? Or the first month or you sign that lease. You're like, wait, but this is like 3 times, like almost double the amount you told me the rent was going to be. I love it. without regard to how these fees or expenses are designated and the due date for those payments. The landlord shall include the same disclosures in any advertisement or other promotional material that the state's periodical rental rate and shall include the disclosures in any web-based promotional materials, including the website for rental premises. I love that. Because they'll show the rent. Rent's $1,100, rent's $13, rent's $15. But then after all the fees and stuff, you get to the lease, you realize, no, my rent's not $1,100, my rent's $1,400. In Arizona, if you don't remember, if you go back to some of the pending, the laws going into effect, Arizona was actually the state that removed the sales tax. Yeah. They said you no longer have to pass the sales tax on down to tenants who are renting, which I don't understand why you would pay a sales tax for renting. And some people were complaining about, oh, the budget. That's the problem. Y'all put in these predatory fees and all these other things and say, oh, what about the budget? It shouldn't have, that's not how you should have fixed the budget in the first place. You should have tried to fix the budget by putting on a sales tax to people who are renting. It's not a sales transaction. Next, any additional fees or costs that may be chargeable to the tenant and that are not included in the periodical rental rate, including charges for trash valet or for upgrades to the rental premises necessary to use smart devices or any other additional fees or costs, including taxes, the landlord shall include the same disclosures in any advertisement or other promotional material that states the rental rate and shall include those disclosures in any web-based promotional materials, including the website for rental prices, okay? We already talked about how to be an advertisement. This is more for the things where they advertise and show you an apartment that is completely upgraded. It's the best you can do. But then when you go around and start looking for the price, they're like, oh, well, that's actually extra to have that. It's actually extra to have that and etc. So that's why it's blah, blah, blah. But we do have base no. Thank you, Arizona, for that. Stop the BS.
Stop acting like a fucking hooligan.
Now, this next House bill is House Bill 2839, and it has to do with the rental agreement, contact information, property, and pets. Now, a landlord may not increase a charge or rental rate that exceeds the maximum rental rate increase prescribed by this section. The maximum rental rate increase for a particular tenant is determined as the follows. The annual rate of increase in the consumer price index. If you don't know what the consumer price index is, I talk about it a lot in the minimum wage videos. Plus an additional 3% of the current rental amount, but not more than 7% of the total annual increase. The Office of Economic Opportunity, established by Section 415302, shall provide annually to the Arizona Department of Housing the appropriate CPI percentage amount. The Department of Housing shall apply the limit prescribed by this section and, on a request of an individual landlord tenant, shall calculate the amount of permissible rent prescribed by this section. The department also shall accept complaints from tenants regarding their landlord's compliance with this section, shall investigate tenants' complaints, and if the department determines that there is a probable cause that the landlord violated the max rental rate, the Arizona Department of Housing shall refer to the matter to the Attorney General for further action. A knowing violation of the max rental rate is an unlawful practice prescribed by this section, and the Attorney General may investigate the matter and seek restitution, and injunctive relief, or other remedies as prescribed by Title 44, Chapter 10, Article 7. Love it. Love it, love it, love it, love it, love it. What they need to go on and say, if there's no visible upgrades to the apartments, no visible creaks, they're not adding anything, you're not adding any services or stuff, you can't increase the rent at all.
Makes sense to me.
If you're not doing anything to actually better the apartment, there's no reason to increase the rent. It's the same as last year. Why we increasing the rent? We ain't increasing shit that's in an apartment.
I need an answer ASAP. Give me an answer.
As I'm just saying. Oh, the price of everything else goes up. Well, what do you think is fucking happening to the tenant inside the rental property? You don't think the price for everything around them is going up? So you as a landlord can take your job, okay, I'm gonna give myself a raise so I can afford everything. But the tenant that's living in there with their jobs, there's nothing being pushed. And I always said this, if landlords did more to push at jobs for affordable rates and things like that, people wouldn't be on the landlord's necks. But now landlords, you gotta blame your job. No. Because you have a job where you can give yourself a raise to fit whatever the consumer price index, whatever you need for inflation. Your tenants probably do not. Another reason why I feel like a landlord shouldn't be a job.
Damn bitch.
Now, a person in this state may not use any algorithmic price fixing to establish the rental rate. There is a rebuttal presumption that if a person committed an antitrust violation or violation of Chapter 10, Article 7 of this title, if the Attorney General proves all of the following factors. A person uses an algorithmic pricing that included non-public competitor data. A person used algorithmic pricing to set or recommend residential rental rates. At least two of the competitors use the same algorithmic pricing for residential rental rates in the same or related markets. Okay, they did it together. The presumption that's prescribed in subsection B of this section is rebuttal if the defendant provides by clear and convincing evidence that the defendant did not develop or distribute the algorithm used in the algorithmic price and did not have actual knowledge or could not have reasonably known that the algorithm used in the algorithmic pricing contained non-public competitor data. The Attorney General is going to be the person to enforce this section. Okay? I'm not mad at any of those landlord-tenant laws because I feel like over the years, landlords have been getting a lot of the upper hand. And it's like, why? When a majority of the people are paying rent. Majority of the world is in landlords. Americans really need to start showing their government that when you piss off the majority, it's not going to be good for you. And I feel like we don't do that enough because too much of the people that are part of the majority think that they're not fucking part of the majority. But moving on, like, howdy. How would y'all feel about to start the video with howdy, y'all? That is the official state greeting of Arizona. Nothing crazy about it. I don't feel no type of way. I just thought it was interesting, so I would put it in here. But that is all I have for this video. Let me know y'all thoughts in the comments. I really want to know y'all thoughts on the sex-based terms. Okay, and I also want to know y'all thoughts on the landlord laws. I'm starting to feel like a lot of even state legislators, etc., they're really on things like Threads, Instagram, TikTok, Twitter, or X. Okay? They're listening. They're listening. If not, Arizona's people are definitely listening. Illinois' people was listening to them about healthcare. So I'm not mad at it. But that's all I got. Let me know y'all thoughts in the comments. I'll talk to y'all later. Bye.
For me, break, for me, break the body for me.